Well, it depends on what the position of the court is, but I think it'd be helpful if you can put your submissions to the extent you want to elaborate.
I object, sir.
And I'll ask Mr. Glew in a moment for his response to them. And that doesn't mean we would necessarily determine the question of cost, but if it's convenient, would it allow you to determine the matter completely, then you would do so. But follow no prejudgments of what the outcome would be.
Thank you, Your Honour. Then I would just elaborate briefly on the submission. The virtually identical circumstances arisen before in connection with these pre-exam principal proceedings.
I object, Your Honour.
Yes, what's your objection?
I object first with you debating anything to do with cost. Costs are issued under Supreme Court rules, which is one of the issues before you, and it is a ruling of the High Court in Lane versus Morrison that the court can't make rules or laws or regulations. You cannot go outside that or you put yourself in contempt of the High Court, sir.
All right. Yeah. No, I think the way it works is we hear submissions on this, then we hear submissions from you. We'll hear your submission in a moment.
I realise that, sir. In relation to costs, it's against the Act of Habeas Corpus 1640. 1 Charles chapter 10 says without a jury they can't get costs. I would deny the jury.
Yeah, but thank you for his comments.
Thank you, Your Honour. So the matter is relatively indistinguishable from the previous decision of Glew and Practice Department of 2008, WSCA 186. And in that case, essentially the basis for which Your Honour and Justice Pullen ruled in favour of the special costs order for my client was at paragraph 18, there is nothing in the grounds of appeal to suggest they had any merit. And comments.
I object to that being brought up, sir. It's a legitimate objection to him putting that case, sir, on the grounds Mr. Pollan said as an independent single judge, contrary to the Act of Habeas Corpus. It's a start-standard hearing when only one judge sits in judgment of any issue. It's contrary to the inherited law, sir.
Mr. Glew, please let Mr. Blunden finish and then you can make submissions in response to what Mr. Blunden says. Yes, Mr. Blunden.
The only other comment I need to quote from paragraph 18 is where Justice Pullen said that the last ground suggests that the appellant still wished to run an argument dismissed in other cases referred to the previous departments. The gist of the thing, it's one of the example of arguments that have been run before and ruled upon for years. We applied in that case for indemnity costs for the award specially gave us a special cost order that is invoked 1972 scale. It's the same situation again, Your Honours. It's simply that the way the scale operates, it would allow effectively, if you were successful, an amount of something like $90 for an amount of small notice. It's just the way the scale. We simply make a point that, as in every other instance where this is a report, an application of appeal of this motion has to be dealt with before it today looks at the merits of the matter. We have to look at the documentation, consider it, advise our client accordingly. There's an issue of whether it's a final decision appeal from or interlocutory. There's a situation of counterclaim referred to the defence of the principal claim on my client. They're all matters that incur time and cost, and unless we were to receive a cost order from both of my compared to the client would not be compensated in justice. Thank you.
Yes, thank you. Now, Mr. Glew, what's being considered now is a question of what, in the event that the court would find against you, what should happen with the costs of this hearing. Now, heard Mr. Blunden's submissions, they submit that if the court finds against you, then there should be a special costs order.
There can't be a cost order.
Do you want to say anything in relation to that matter in respect of costs or any other matter in respect of costs, depending on the outcome of the proceeding? Then I invite you to do so now.
Well, in respect to the cost order that he is attempting to claim, you can't issue it. It is contrary to inherited law. You cannot disobey the inherited law. I'm not trying to tell you what to do, but the High Court has ruled several times in relation to our inherited law, but the Act of Habeas Corpus states completely at 1 Charles chapter 10 that a cost order cannot be issued without a trial by jury and the jury sitting in a judicial function. Now, we didn't have a trial by jury because Mr. Blundell and Mr. Martin decided we can't have it. Now, the issue with this, what I just said, is Mr. Martin on the 23rd of July said there was too much paperwork for you to have a trial under the Supreme Court Act. So therefore you can't have it. And then we see the gentleman going to court a couple of weeks ago with a couple of truckloads of paperwork. But he conferred with Mr. Blundell. He said, isn't that the case, Mr. Blundell?
Yes, so just for the case, if I can get the submission correct in my head, the submission essentially is by reason of the historical law, including habeas corpus.
Yes.
The court wouldn't have the power to make a cost order.
Under habeas corpus and again under Supreme Court rules because they were invalid under Chapter 3 of the Constitution, the inability of the court to make rules and laws.
So no power to make a cost order.
No powers whatsoever, sir.
Anything else beyond no power?
No, sir.
Thank you, gentlemen. We'll reserve our decision.